Right. Anthony Juarez for the people. May I proceed, Your Honor?
Yes.
Now, Mr. Roman, you told us just now that you can't come to any conclusion about what caused the accident.
That's not true. I can't tell you definitively what caused the accident. What I can tell you is that there are several possibilities. Possibilities of hydroplaning, visibility issues, or an animal darting in front of the road.
But you just testified that you couldn't come up with what the stimulus for the accident was. Isn't that right?
That's right. I can't tell you which of those three possibilities is the most likely.
Now, when you compiled your report, Mr. Roman, you didn't inspect the vehicle until 18 days after.
That's correct.
In fact, you weren't able to get to the road until 18 days after. Isn't that right?
That's right. I wasn't hired until 18 days after the accident occurred.
Right, but to direct you back to my question, you weren't able to inspect the road until 18 days after.
Correct.
So, you've testified for the defense in the past. I mean, not this particular defense, but the defense in criminal proceedings. Isn't that right?
That's right. In criminal proceedings, I usually testify for the defense. The prosecution has the police to testify for them in accident reconstruction cases.
Mr. Roman, do you usually testify for the defense, or do you exclusively testify for the defense?
I always testify for the defense by necessity.
Now, you were hired by the defense to test the specific scenario of a deer running in front of the road. Isn't that right?
Right, that is one aspect of my investigation, the possibility of an animal darting in front of the road.
Right, but specifically you were hired to test the plausibility of a deer in specific in this situation. Isn't that right?
Yes, that is one part of my investigation. It's absolutely correct.
You were paid $200 an hour to come to your conclusions, right?
That's right.
You worked for 25 hours.
That's right.
So you were paid $5,000 total.
Exactly. This is my career.
Right, and now you've been on the stand for about 10 minutes now, and you're being paid $2,000 just to be in court today. It's about...
Objection, Your Honor. Argumentative.
Where's the argument?
Opposing counsel stated you've been on the stand for about 10 minutes. You're being paid $2,000 for being on the stand today, as I heard it.
Your Honor, maybe.
I'm sorry, I heard it exactly that way too, but where's the argument?
Well, counsel's claiming that this witness is being paid for being on the stand today for his testimony.
Your Honor,
Yes.
heard?
Your Honor,
Are you disputing that he's being paid for testifying today?
no, Your Honor.
Okay.
As I understand it, I believe opposing counsel stated that you've been on the stand for about 10 minutes and you're being paid for testifying. I feel that it's characterizing the testimony as a witness in a misleading way.
Maybe, Your Honor?
Would you like to respond?
There's absolutely nothing misleading about how I'm trying to characterize this witness's evidence. I am entitled to, in cross, to question the credibility of this witness for the jury's sake. This witness has, in fact, been on the stand now for about 12 minutes since we've had this argument. But at the time I asked, it was 10 minutes. He's being paid $2,000 to be here. These are all facts.
Your Honor, may I respond?
Sure.
As I understand it, opposing counsel asked no question when he stated you've been on the stand for 10 minutes. He's testifying. He's forming an argument.
Well, I think he was trying to state his question, and then you objected, so he couldn't finish his question. So your objection's overruled. You may ask your question.
Now, Mr. Roman, you've been on the stand for now 13 minutes, and you're being paid $2,000 to be here in court. Isn't that right?
That's right.
And when you came to your conclusions in this case, you heavily relied upon the rutting. Isn't that right?
Yes, the rutting was one aspect of my investigation, absolutely.
So, but it was pivotal in coming to a conclusion about what the stimulus was. Isn't that right?
I wouldn't say it was pivotal, it was certainly an important aspect.
Right, so, and you also supplemented Officer Foster's fatal crash scene report with some pictures that you took of the area that you thought were important, right?
That's right, I did take several pictures of Canyon Road to assist me in my investigation.
Right, but you didn't take any pictures of the rutting, did you?
I did not.
Even though the rutting was important. Isn't that right?
No, I factored the rutting into my diagram of the area, but I did not take any photographs of it.
Right, for the jury to see. But you just testified in your direct examination.
Objection, Your Honor. Argumentative. For the jury to see. Counsel's testifying.
Overruled.
So, you testified in your direct examination, opposing counsel, that you can use a combined speed formula and use crush factors to come to your conclusions about how fast the vehicle was going. And you said that the friction from the rutting was important in coming to those conclusions. Isn't that right?
And the friction both from the rutting and from the pavement. Two different friction values because the rutting took place on a grassy part of the road and the accident took place on the pavement. It's two different friction values.
Exactly, but you needed the friction value from the rutting, but you didn't bring a picture, did you?
No, I have no picture of the rutting with me.
Now, Mr. Roman, you've taken a course called Human Factors in Accident Reconstruction. Isn't that true?
That's true.
Now, and you've also evaluated the affidavits of a few of the witnesses. Isn't that right?
I have.
Specifically, you evaluated the affidavit of Taylor Hobson, correct?
I did.
And in Taylor Hobson's affidavit, she states that the defendant was drinking. Isn't that right?
Yes, Taylor Hobson does make mention of that.
Now, in your report that you conducted, you didn't.
Objection, Your Honor, hearsay, if I may be heard.
I'm sorry, hearsay as to what?
As to Taylor Hobson stating that the defendant had been drinking. May I explain further?
Okay, sure.
If I may direct the court's attention to case law Richards v. Mississippi Barbecue. I believe it's on the third page. It should be the second or third case law. It states that experts cannot be used as conduits for hearsay. In this particular instance, opposing counsel is asking Professor Roman about what Taylor Hobson said solely for the purpose of drawing out that testimony. That testimony is being backdoored in through this expert, and he's being used as a conduit for hearsay. It's inadmissible.
May I be heard, Your Honor?
Yes.
This is in absolutely no way being used as a conduit to bring backdoor evidence of the defendant drinking. We've already had our entire case in chief where we highlighted that in extent. What I'm trying to do right here is, and like you heard me ask the witness, is ask him if he's taken a course called Human Factors in Accident Reconstruction. By asking the fact that the defendant was drinking that night, and by the fact that he knew and didn't include that in his report, questions the entire validity of everything this witness has testified about. How can he not...
Restate your question for me, to which defense just stated an objection.
The question was, you reviewed Taylor Hobson's affidavit, and you didn't...
Your Honor, if I may respond.
Well, you can't respond till I hear what it is that you were objecting to.
Okay,
So tell me what the question was again.
I asked him if he reviewed Taylor Hobson's affidavit, and then I was going to ask if he accounted for the fact that the defendant, Daniel Dawson, was drinking when he conducted his report.
Okay, go ahead.
Your Honor, opposing counsel stated that in his question that Taylor Hobson, you reviewed Taylor Hobson's affidavit, and Taylor Hobson stated that the defendant had been drinking. Now, this information does not use any of the expertise used by Professor Roman himself. According to Richards v. Mississippi Barbecue, an expert cannot simply summarize the testimony of others without first relating that testimony to some specialized knowledge on the expert's part as required under Midland's Rules of Evidence 702. Now, stating whether or not he knew that Taylor Hobson stated in her affidavit that the defendant had been drinking does not use any specialized knowledge on this expert's part.
May I be heard, Your Honor?
Yes.
And that's why I asked the question about whether this particular witness has taken courses entitled Human Factors in Accident Reconstruction. I'm about to get into the fact that this was a human factor that he didn't account for. We qualified this witness as an expert. The opposing counsel used him in the direct examination. Now we're going to ask him why he didn't include it. He's taken courses in it.
Yes. We qualified this witness as an accident reconstruction expert. He has no expertise in blood alcohol concentrations, in anything regarding alcohol or the effects of alcohol in the human body. One course doesn't qualify this expert as an alcohol concentration expert, and this information is not using that expertise. Therefore, it's still hearsay.
May I be heard, Your Honor?
Yes.
We're not trying to qualify this witness as an alcohol pharmacologist in any way. This witness has taken courses in Human Factors in Accident Reconstruction. A human factor in accident reconstruction would be a person being under the influence of alcohol.
Your objection's overruled. You may continue.
And Mr. Roman, like I said earlier, you've taken a course in Human Factors in Accident Reconstruction. Isn't that right?
Yes, and the human factors in question are questions on the accident reconstruction engineer's error. It's basically a class on how to avoid errors.
Now, Mr. Roman, you can't tell us for a definitive fact that there was a deer in the road.
No, I can't tell you whether or not there was a deer in the road. I can't tell you that it's a possibility.
You can't conclusively tell us today in court what was in front of the road, in front of the car as it was driving down the road, can you?
No, I can't tell you what exactly was in front of the car. No.
All right, no further questions this time.
Thank you. Redirect?
No to redirect, Your Honor. May this witness please be excused.